All right. Yeah. I have.
Use the microphone at desk.
Yep. I have on mute. Can you all hear me? Still getting a little echo though, even with the microphone. I am on mute. Hold on, guys. Just trying to figure out the echo. Doing test. Good? Okay. All right. Sorry about that. Can everybody hear me? Thumbs up if you can hear me. Okay, I see merit. That's good. Okay, welcome everybody. We are just waiting on a couple of people that are joining, and then we'll get started in probably about 2 minutes. Okay. Right. All right, it looks like the last has joined. So I'm just gonna call the meeting to order. Today is April 22nd. It is, I think, 1:08 p.m. And so we'll get right into the agenda. I'll just start with welcome and introductions. I'm going to start with the folks in the room and then move to the folks that are joining virtually. So hi, everybody. My name is Megan Scanlon. I'm one of the co-chairs of the DV Council representing the Connecticut Coalition. I know my co-chair, Senator Flexer, is actually bringing out bills right now. It's a session day, so she won't be able to join us, but I just wanted to mention that. And I'll move to Chief Fox. We'll go around this way.
Good afternoon, ladies and gentlemen. Alaric Fox, Chief of Police from the Enfield Police Department. It is good to see everyone again.
Good afternoon, Johanna Canning, designee of the Chief Public Defender.
Good afternoon, Nancy Turner, representing the Connecticut Board of Pardons and Paroles.
Good afternoon, everyone. Shauna Harrington, Director of Legal Advocacy at CCADB.
Hi, everyone. Joe DiTuno, Director, Judicial Branch, Family Services.
Hi, everyone. Danielle Cinquedolce, Regional Manager with the Judicial Branch Family Services.
Good afternoon, Valina Carpenter, Office of Policy and Management, Criminal Justice Policy and Planning Division.
Good afternoon, Karen Foley O'Connor, CEO of the Network Against Domestic Abuse in Enfield, one of CCADB's member organizations.
Great, thank you. I'm just gonna call off those that I see on Zoom. First up is Gail.
Good afternoon, everyone. Gail Hardy, Chief State's Attorney's Designee.
Great, welcome. Andrea.
Good afternoon, Andrea O'Connor, Family Violence Victim Advocate, Program Manager at the Umbrella Center for Domestic Violence Services.
Thank you. Ginger.
Hi, I'm Ginger Wilk. I'm the Senior Director of Reentry Services for Community Resources for Justice and Family Reentry.
Judge Doyle.
Good afternoon, Kevin Doyle with the Superior Court.
Welcome, Chief Rosado.
Good afternoon, Rob Rosado, Chief of Police in Meriden.
Welcome, Merritt.
Good afternoon, everyone. Merritt LaJoy, Office of the Victim Advocate.
Great. And it looks like I see Ryan Maynard and then Michael.
Good afternoon, Ryan Maynard, Captain of Connecticut State Police.
Mike Tatro, Legal Project Manager, CCADV.
And Jessica, I think that's it.
Jessica Sedlowski, Community Coordinator with the CCADV.
Great. Okay. All right, great. Moving on to the approval of the February meeting minutes. Can I just get a motion to approve?
So moved.
Second.
Great. Any discussion, edits, changes? Okay, hearing none. I'll call the meeting minutes to a vote. All in favor? Great. All
Aye.
opposed? Any abstentions? Okay, great. Hearing none. Going into subcommittee reports, police response to crimes of family violence. I do want to just note that you probably just received some language, so I'm going to give folks about 5 minutes or so to read through that language, and I apologize, that's an oversight on our part. So I will give folks like 5 minutes to just read through. You should have gotten model GPS language and jurisdiction language. Did that go through? Emailed it out?
Yes.
Okay, so I'm just gonna give folks like however long they need, but 5 minutes. And if you need more time, to read through that really quick before they go into their report, if that's okay.
Madam Chair, who would we be looking for that from?
It would be from Liza's email,
Thank
Liza Andrews. And it did come through to my email. It looks like, if you didn't get it, let us know.
I did not receive the email.
Okay. All right, I'll re-forward it. Joe, you said you got it, you received it. Did everybody in the room receive it?
Yes.
Can you just clarify what the attachments are called?
It should be model policy GPS language, and then the other one should be jurisdiction language. They're both drafts. And Mara, I just sent it over to you again, and apologies for this, this oversight.
Okay, thank you.
Right. And for folks that are just joining, I see Senator Flexer joined and then Representative Leeper joined. Just as an update, we're just taking a few moments to review some of the language that the Police Response to Crimes of Family Violence Subcommittee is going to go over. If you did not receive it, just let me know. Merritt, did you get it? Okay, great. Yeah, all right, thanks. Sorry. Senator Flexer, do you have a question?
Yeah, I'm just wondering, are we looking to approve this to be added to the model policy today?
I think we can probably have it as discussion for today, just given the fact that folks have not had a chance, and that, again, that's our oversight that it didn't get sent out with the packet. And I think the goal would be to approve it at the next meeting.
That sounds great. Thank you.
Yep. I'm gonna give it till 1:20. Does that give everybody enough time to have read through it? Okay, all right. I think I'm seeing most folks in the room as well as on Zoom are ready to proceed. So I will turn it over to Chief Fox and Karen for the subcommittee report.
Good afternoon, once again, ladies and gentlemen, and thank you for the opportunity to be with you. The Police Response Subcommittee, in our work over the current cycle, has identified two areas that we thought were appropriate for updates, improvement, tweaks, somewhere along those lines. And subject to the chair's input, I suppose I'm going to suggest that I raise the first one and then open it up for questions or concerns and then circle back to the second one. The first one, which is the Domestic Violence Alert Notification GPS program, is longer by volume, but probably easier to read and understand technically. The second issue that we will discuss is a little bit more complex, and it has a I'm going to make your brain hurt deep dive into the statutes. But at least it looks shorter when we get to it. I will start, however, with the Domestic Violence Alert Notification GPS program. Credit where credit is due. The phrase yeoman's work for Joe DeTuna and my co-chair, Karen Foley O'Connor, does not begin to give them enough credit because they sat down. I think they locked themselves in a room and they, hid the key until they were able to hammer out what needed to be done here. So that we understood the language they were speaking and they understood what our needs were. And what is before you, 1, 2, 3 pages, is an effort to include in the model policy an up-to-date understanding as to how the Domestic Violence Alert Notification GPS program works and how it's usable and when it's usable and what it is as a resource for law enforcement officers that respond to these scenes. Allow me to be the first to acknowledge, and admittedly, I'm not in a radio car responding to these calls directly these days. But I do think it fair to say this is an area that largely is a little bit hazy for law enforcement, even folks that are out there on a day-to-day basis. We know there's this program. We know that Judicial runs it. We know that it has relevance to us. We're not really sure exactly what the edges or the parameters are of how it is that we can use it. So in an effort to address that confusion, you see the 3 pages that are before you. So we begin page number 1, largely some introductory language that explains the program, that explains its history, that distinguishes it from what probation and parole use for their electronic monitoring system. We explain the different types of zones, buffer zones, exclusionary zones, and mobile zones. And then we go on to explain when alerts, what an alert is and how an alert is triggered. Jumping up onto the top of the second page, if an alert is triggered, the GPS monitoring company and then their responsibilities. And this begins to get us to a point where law enforcement is going to be notified when there is a breach under the circumstances where there is a breach to the electronic monitoring protocol in these cases. By the middle of the second page, we are up to officers dispatched to an AN GPS call should. And then we have those steps that we expect police officers to take in response to such a call for service. I will take just a moment and clarify one apparent error if you're looking at the electronic version versus the paper version, because to the credit of the subcommittee, when good work is being done, we have multiple copies of this document and they're zipping back and forth and multiple people are trying to look at the same thing and they're offering commentary and the commentary is being incorporated and someone else has not yet had the opportunity to look at it. We have one removal that is needed on the paper copy. About midway through the second page, you're going to see a line that reads now, if after the safety of the victim has been reasonably verified, and as was properly pointed out, Merritt, I believe by you, and I thank you for that when we were together as a subcommittee, the word if is redundant and frankly probably inappropriate because we do want officers to verify the safety of the victim. So it's not a matter of if. It's a matter of go out and do it. If you are reading from the electronic copy, the one that was forwarded to you, as I'm looking at now, and forgive me as I'm scrolling on my phone, the word if is still there, but the highlight isn't showing up. So the paper copy has it, and it's highlighted, which to us meant make sure that is removed. The electronic copy has got it in there. Please know that we know that it's supposed to be removed. That's why it's highlighted in the paper version. We continue on to the bottom of page 2, talking about what the officer is going to do in regard to the alert. And then the part that I think is probably the most significant, at least for the folks that I work with, how does a law enforcement officer liaison with the GPS company to get the offender points as part of a follow-up investigation? And that is all set forth on page number 3, including how we would go about accessing Court Support Services Division. The language on these 3 pages, it doesn't necessarily have a aha moment. We spotted an error in a statute. We spotted a weakness in terms of what we have for a protocol or a policy. We've just identified this as an area where there's some confusion and perhaps not as much assistance from the policy as it could have. I'm always very cognizant, final thought, I'm always very cognizant about the length of this policy. I am worried that in an effort to do good work, we've created a document that is so voluminous that I worry if officers might skim it sometimes. However, I would offer to the group that this is 3 pages well spent, even if it is increasing the length of the document. Thank you.
Okay, thank you, Chief Fox. Any questions or comments on the language?
I just want to add to what the chief said. I think in our group, our subcommittee, our goal is to make sure that we get information out to everyone universally here in the state. And that by getting this in the model policy, we're going to know that it's going to be in every policy. And by virtue of the how we're operating as far as a committee on the different sort of calendar, this allows us to ensure that this will be part of the model policy, which will be in a red book that most officers subscribe to or carry with them. So GPS may be one of those things that you're not going to realize that you need to know a lot about it until the moment you need to know a lot about it. So this will get us to that point. And I want to add that hopefully this just involves more communication, better communication between the program and law enforcement. And I want to thank Joe DeTuno for really helping me out with this, to really simplify it, to make it something that law enforcement is going to be able to use and will build trust and faith in the GPS notification system as well.
Thank you, Karen. Any other questions or comments?
Can I just ask, as being new to this commission, is this policy a new policy or is it amending existing policy?
The latter, it is amending existing policy. Thank you.
Good question. Any other questions either from Zoom or in the room? Yeah, Nancy.
So Chief, top of page 2, under an alert is triggered if letter D, a GPS signal cannot be located and the victim requests a well-being check. I had a question about the and whether who the victim's going to request the well-being check of if this is under the GPS monitoring company.
Chief Fox, want me to answer that?
That would be great. Thank you.
So there are times where defendants are in places of work like a factory where there's no ability for the GPS points to connect. We know that the person's there. My office will contact the defendant and say, you know, it seems like you're in a warehouse and Sentinel's going to call you to get a point. At the same time, the victim is notified. There are some victims who don't wish law enforcement to go to protect their safety if they know it's an environmental issue and not a safety issue. There are some victims that are like, I'm getting alert. I want law enforcement to do a wellness check. We would do that for that person, but we're managing that issue, that environmental factor. Because once they get points, it works. But there are places that there's no windows and there's no ability to get a signal, and the offender is notified, and we want to make sure the victim is fine. Usually, the victim says, "I understand. I know he's at work." As an example, the other times they're like, "I don't know where he is. I'm concerned. Can you send an officer for a wellness check?"
The signal can't be located.
So as an example, it's not a strap tamper
Yeah.
because that alert didn't come through. So we know that there's an environmental factor. So we are Sentinel's calling the defendant to get them outside so that a point can be detected. We're family relations counselors who are monitoring will call the person. But it's usually something that could potentially be chronic. But if a victim, as part of the protocol, the victim is contacted, and sometimes they don't wish law enforcement to be sent. They would not be automatically sent for something like that. It's if they request it.
Okay. All right. Thank you for that.
Does that answer your question? Okay, great. Any other questions or comments? Karen.
I just want to clarify that this section here will replace the current GPS section that we have in the policy, which is outdated, doesn't represent that it's active at every courthouse now. So that section, and Chief, do you know the page off the top of your head?
I can find it,
Yeah.
but not off the top of my head.
Currently, that whole GPS section will come out and this would replace it, just to clarify that.
Thank you. Any other questions or comments from either in the room or on Zoom? Okay, I am not seeing any. So Chief, you want to move on to the jurisdiction?
I'll be happy to.
considerations?
And in response to the final question, it's going to be somewhere around page 18 in the current version of the model policy is where the alert notification GPS program language exists at present. So that would be replaced by the language before you if and when we get to a point where the full committee votes to adopt that language. The second area of intention, work, deliberation on the part of our subcommittee is the jurisdictional concern language. And we are going to advocate that this be included probably somewhere around pages 12 or 13, where there's a general discussion about jurisdiction, but this is not replacement language. This is new. So I'll start with the following, and forgive me if this is painfully evident to everybody in the group, but it might not be everybody. Under Connecticut General Statute 54(1)(f), law enforcement has jurisdiction, sans the state police or other statewide agency, which would have statewide jurisdiction. Local law enforcement agencies under 54(1)(f) have the ability to investigate and perhaps more importantly, make an arrest for any crime that occurs in their jurisdiction. So in my case, it's the town of Enfield, except felony offenses can technically be taken and investigated and arrests being made anywhere in the state. Having said that, I would not take or make a felony arrest outside of Enfield other than in a life safety type of situation. So I'm going to introduce the jurisdictional considerations discussion with that general awareness that 54(1)(f) is this overarching statute that we need to be concerned about, especially on the local law enforcement side, as it offers a restriction on who can take what cases. Largely, local police departments are going to take misdemeanor cases in their jurisdictions, felony cases in their jurisdictions, but they could not take, as a matter of law, a misdemeanor case from outside of their jurisdiction. And the significance of this, as you're going to see, is what I think may have been a reluctance over the years, or at least a concern on the part of local law enforcement to take cases that felt like they belong to another municipality. That's the core of what we're dealing with here. So with that in mind, the one pager that you have on jurisdictional considerations is really nothing other than an effort to describe the current state of the state, if you will, what the legislature has kindly done for us in some specific offenses that are very often domestic violence related. And rather than have officers, if they were even up for it, searching through the statutes to try to determine jurisdiction for a given type of offense, because the statutes do tend to point you from one place to another, to another, to another. What we've done here, and we're going to need to stay on top of it, but we've done here is tried to reconcile who has jurisdiction when. So electronic or telephonic communications, specifically under 54(1)(r), and footnote, that's a statute most police officers are never going and looking at. It's buried in the criminal procedure section of the law. It's not in 53A, it's not in 53, it's not in Title 14, it's not in 21A. It's not a place where we feel comfortable. 54(1)(r) is the statute that, as you see on the top of the page, says that for the offenses of 53A 223, 53A 223A, or 53A 223B, and those statutes are criminal violation of a protective order, criminal violation of a standing criminal protective order, and criminal violation of a restraining order. 53A 223, 53A 223A, 53A 223B. 54(1)(r) does say, without regard to that 54(1)(f) formula that we're very used to working with, jurisdiction for these three offenses can be, number one, where the person resides, where the person received the communication, or where the communication was initiated. So what the legislature has effectively done is they peeled three of them off, and they said for these three, any of these three jurisdictions can take it. And then they went on to say, in these instances, under 54(1)(r), the agency also must do, and these are the 5 bullets that sit directly below that, such law enforcement agency shall 1, 2, 3, 4, 5. Footnote, I hope every law enforcement agency is doing all those things in every case anyway, but those 5 things are flowing directly from 54(1)(r), and that's why they have to be in this section and only in this section. If you're not confused yet, now I'm going to continue on and see if I can get you there. We have also said in 3 other statutes that we think are are frequently used in domestic violence contexts, specifically harassment and stalking in the first degree. I'm sorry, harassment in the first degree, harassment in the second degree, and stalking in the second degree, 53A 182B, 53A 183, and then finally stalking second, which is 53A 181D. If you happen to be looking at a version where the statute is listed as 53A 18DD, you've got a slightly older version of our work product. So 53A 182B, 53A 183, and 53A 181D. What the legislature did there is in each of those individual statutes, not in 54(1)(r), in each of those individual statutes, they went down in subsection B of each of those statutes and they said, for the purposes of this section, the section we just talked about, such offense may be deemed to have been committed either at the place where the communication originated or at the place where it was received. So now we have 3 statutes where we're trying to point to police officers or point out to police officers that if you're dealing with one of these 3, it's only these 2 municipalities, only these 2 communities that could appropriately be said to have jurisdiction. I certainly would not and do not remotely think the legislature made this confusing on purpose. I think 54(1)(r) was an effort to make it easier for us, but it only captured the first 3 statutes. So these other 3 statutes are left in this land where only 2 communities would have jurisdiction, and any other domestic violence or any other statute, and we've got a couple of examples for you, we are left in this land where we're trying to figure out which police department is the appropriate one to take it. I know that in the advocacy world, the stories that you have heard, and folks, I cringe when I hear this, not because I take it as a criticism, I cringe because I think you're right, is that sometimes your victims are telling you they've gone to a police department and they've gotten this between different agencies. I don't think that's malicious, but I do fear that's because of the ambiguity that you're seeing right here that we are trying to reconcile. I will save, if the chair thinks it's appropriate, for a final piece of the discussion, the statutes that we think are highly relevant for update or modification for the end, because we have at least 1, 2, 3, 4 statutes that remain in that there's no guidance, and they're highly likely DV statutes. But unless the chair wishes to the contrary, I'll be quiet now and let the group digest just this page.
Okay. Let's have the group digest this part first, and then we can move on to the statutes that you're referencing. Any questions, comments on the jurisdictional considerations? And thank you. That was a really great job of a very complicated process. Sure, Karen.
I just want to capitalize on what the chief said. I think our goal, being someone that has experience working as a police officer and now has experience of working in an advocacy world where it is frustrating when victims report that they've been sent to many different places. I can see myself in a place as a police officer where this isn't making any sense to me, and I'm not sure what the right thing is. So we did this in an effort to make it really clear, again, in the Red Book, so that we can let victims know that, hey, I can come here and this is why. And this is the goal, to just make it simple. And we'll go on ways we can continue to do that. More questions if anybody has any.
Thank you, Karen. Any questions or comments? All right. I am not seeing any other questions or comments on this language either in the room or on Zoom. So do you want to move forward with the statutes?
I will, and I'm sure there's no comments because I've confused the crowd and they just don't want to hear anymore, as opposed to it was crystal clear,
I
but
see Chief Rosado is laughing, so.
I will take it, I will take it either way. Okay, I guess as a final point and an addendum to the discussion on jurisdiction. So 54-1R has got these three statutes that give jurisdiction to any of three agencies. The harassment stalking statutes give jurisdiction to either of two agencies, and yet, and there's a real irony here because one of the ones in the second group is stalking second. Well, stalking first degree, 53A 181C, as well as stalking third degree, the statutes immediately before and immediately after stalking second do not have any clarifying language. So it's stalking first, 53A 181C, stalking third, 53A 181E. Electronic stalking, admittedly a newer type statute, 53A 181F. And then unlawful dissemination of an intimate image, 53A 189C, that my subcommittee would respectfully suggest the big picture committee and our very positive relationship with our legislative members that join us and are part of this group may wish to consider either including them in 54-1R, including everything in 54-1R, or at least expanding the current language of harassment first, harassment second, and stalking second to include those 1, 2, 3, 4 additional statutes. That is admittedly, however, more of a long-term legislative goal than a policy goal that I think our group can directly accomplish.
Great, thank you. Any questions or comments from folks in the room or on Zoom?
Just Chief, if you could, I got the stalking first and the stalking third. But if you could show over again what 53A 181F and 53A 189C are.
Yeah, happy to. Stalking first, 53A 181C. Stalking third, 53A 181E. Electronic stalking, 53A 181F. And then unlawful dissemination of an intimate image, 53A 189C. One more time or good? Good, thank you.
Any other questions or comments? No, I think it makes sense to sort of pursue what it could look like in terms of a recommendation for the report for the end of the year. And then obviously our legislative partners on the council can collaborate with us on those suggestions. Any other final comments or questions before moving on to court-based issues subcommittee? Okay, I will just add, just for those that joined a little bit later, the language that you received today meant to review and to have a discussion here today. We will be including it in the July packet to actually vote on and approve. So if you do have comments or suggestions or edits, please get those to Karen or Chief Fox, or also Mario or Liza from our team. by like the middle of June would be great. So that we can update it and get it out to folks. Does that sound fair? Okay. All right, great. All right. Thank you to Chief Fox and Karen that, again, you guys are always doing amazing work with your subcommittee. And so with that, I will move on to court-based issues. I know you have also been really busy. So Merritt, are you
Yes.
the update? Great. Awesome. I'll hand it
Good
over to you.
afternoon again, everyone. Yeah, we've been quite busy. Our last meeting was very productive. Again, we continued the discussion around the supervised diversionary program. We have our roundtable scheduled now for May 13. Joe and Danielle are putting together that agenda and the invites. So we're looking forward to that, and hopefully at the end of that roundtable, we're hoping that there'll be recommendations to the larger council. The training for prosecutors regarding the supervised diversionary program is tentatively being planned for the fall. So if everything goes well with the roundtable, that's what the plan would be for the fall training for prosecutors and judges and everybody, I think.
Merritt, I apologize for interrupting you. Will you be able to send, we can send that out to the council too, the roundtable invite when you have it?
Yeah, Joe?
Will you have, can you just make sure that we can send it out to the full council as well?
We have a calendar holds, but when the official invite comes, we'll send it to everybody.
Okay, great. Yeah, just make sure we get, if you can send it to Mario and Liza so we can get it out to everybody, that would be great. Thank you.
Okay. We did discuss the clean slate law. We had a nice robust discussion regarding it. We think that the intent of the legislature was to exclude all crimes of family violence. However, 46B 38H, where the list of crimes are contained, there's a number of crimes that are not included that we consider to be family violence crimes. So what we did was we went through all of the crimes. The most concerning one is the assault third charge, which was a real surprise. And we had a conversation about breach of peace and disorderly conduct being included, yet assault third is not. So we went through the list, and I can give the list. It's not too long, but that we're going to be recommending in our June report to the council as a recommendation to modify 46B 38H to include the following crimes: assault third, 53A 61, threatening first, 53A 6-61AA, unlawful restraint first, 53A 95, unlawful restraint second, 53A 96, custodial interference first, 53A 97, custodial interference second, 53A 98, criminal mischief first, 53A 115, criminal mischief second, 53A 116, criminal mischief third, 53A 117, electronic stalking, 53A 181F, interfering with an emergency call, 53A 183B, violations of conditions of release first, 53A 222, and violation of conditions of release second, 53A 222A. So these crimes are currently not included in the list of family violence crimes that would be exempt from clean slate erasure. So that will be a recommendation that we're submitting in our report to the council on. We did take a vote on that, and it passed by majority vote. And we'll be recommending that in our report to the council. Also, we had discussions regarding the issue of victims being notified of modification of a protective order or to vacate a standing criminal protective order. We discussed at our last meeting statutes 54-227 and 54-228, which directly address victims registering for notification of post-conviction opportunities as well as receiving the notice. And so we'll be voting at our next meeting on this recommendation to put forward to the council. As far as the modification of a protective order, we had a discussion about that. Mark Pelka from the Office of Victim Services is looking into the capabilities of Vine. So we are waiting for more information on that. But as far as the motion to vacate a standing criminal protective order, we are going to be voting on a recommendation at our next meeting to pass on to the council. And our last discussion was regarding some inconsistencies in the confidentiality statutes that relate to victims of sexual assault and family violence. These are in the Freedom of Information statutes in 1-210 and 1-215. And so we had a discussion regarding amending 1-210 to be consistent with 1-215. And so we'll be voting on that as well at our next meeting, and another recommendation that will be in our June report to the council. Our next meeting is May 12th.
Thank you, Merritt. That's a lot of great work that your court-based issues subcommittee has been doing. Does anybody have any questions about any of the topics that Merritt just went over?
I think I just want to clarify, I was part of the subcommittee meeting, but I just want to clarify from what Merritt just said. The confidentiality issue will be voted on in the subcommittee meeting in May. Is that correct?
Merritt, were you able to hear that?
Yeah, no, I can't hear
Okay,
you.
let me try to repeat. The confidentiality issue will be voted on in the subcommittee in May. Is that correct? Just a clarification question.
Yes, correct.
And is that the same with the victim notification issue as well?
Could you hear that? Is it the same with the victim notification issue? Are you talking about Vine, Johanna?
Yes.
Is that the same for the Vine
Yes.
portion?
So no, Vine, we're not taking a vote on. We're taking a vote on when somebody moves to modify or vacate a standing criminal protective order. And that would be amending 54-227 and 54-228.
Okay.
That's what we'll be voting on. We
Okay.
will be voting on the Vine issue because we're waiting for more information on that.
Okay. So if I'm understanding correctly, you have to wait to see what the capability of Vine is before moving forward with that?
Correct. And that would be a modification, yeah, on a protective order during a pending case.
Okay.
Yeah.
Johanna, does that help clarify it?
That does help clarify it for those two issues.
Okay.
And then as far as the clean slate issue, where do we stand on that? I know it was voted out of subcommittee for today's purposes. I was the one objection to that, so I'm just wondering where that stands right now.
I think it sounds like, well, I know one part that we talked about at the last meeting, and I guess you all can correct me if I'm wrong, if you already went through this on the subcommittee side, is I do believe Senator Flexer needs to meet with the legislators that were part of that. I realistically, I don't think that will happen until after session. So I think that's a piece that probably still needs to happen before
That was
things
my
move.
concern, so that
Yeah.
answers that. Thank you.
Yep. Yeah, I know it's a priority for Senator Flexer. I just know that session is keeping her busy at the moment. So realistically, after session, and then once we have that information, you can bring it back to the court-based issues subcommittee.
In my understanding, when we make a recommendation to amend the statute, that's when, if it's approved by everybody, that's when the liaisons get together, right, Megan?
Yeah, I do. Yes,
Okay.
correct. I do know that we talked about at the last full meeting that Senator Flexer would try to convene a meeting with the leaders of the clean slate to try to clarify intent. So hopefully that could inform your recommendation.
Right.
Yeah.
Mhm.
Any other questions or concerns or comments? Okay, I'm not seeing any in the room. I'm not seeing any on Zoom. So I'll move on to the firearm seizure and compliance working group update.
Hello again, everyone. We have had 2 firearms working group meetings since the larger council last met. During our March meeting, Sergeant Brianna Maurice of the Special Licensing and Firearms Unit reviewed the ideal compliance procedure with the group and identified 4 major obstacles preventing the current process from being the ideal process. Those are lack of mandatory registration, what was referred to as the match game, i.e., if law enforcement sees that a person has 4 firearms registered to them and they only surrender 3, there's a lack of investigation that tends to happen to recover the missing 1. 3, people don't sign the DPS 332C compliance statement. And 4, if the case isn't closed out, meaning compliance hasn't been verified, the SLFU does not follow up with law enforcement due to a lack of resources. The group decided to start with exploring recommendations surrounding the DPS 332C compliance statement and ways to get that signed. An idea was pitched to involve bail in the process to have them verify for the court that the form was signed, not that firearms were surrendered, but that the form was signed to say the firearms were surrendered. Bail attended our April meeting and informed us of the barriers to that process, namely lack of resources and lack of access to the database for verification. In advance of the May meeting, the co-chairs have discussed pitching a modification of the form entitled General Notification of Criminal Protective Orders, which is the JDCL 98 form, to the group. This modification idea would include a carbon copy of the notice and a signature line, indicating that the defendant has read and understands that they may be prohibited from possessing or receiving a firearm, ammunition, or an electronic defense weapon. And our next meeting is on May 20th.
Great. Thank you, Shauna. Any questions for Shauna?
I'll just say I don't know if Andrea has anything to add, but she is my co-chair, so.
Andrea, you want to add anything?
Nope, that was a perfect summary.
Okay, great. Any, okay. No, I don't see any questions on Zoom. Any questions or comments in the room? Okay. Thank you, Andrea and Shauna, for your work on that. I know it's a big undertaking and it's going to be a long process, but hopefully we'll have really good recommendations that come out of that. Okay. Hearing no other questions or comments on firearm seizure, I'm going to move on to other business. Anybody have anything that they want to bring up in other business? I don't see any in the room and I don't see any on Zoom. So the only thing I have is that the next meeting will be July 22nd at 1 p.m. And just as a reminder, we set that at the last meeting. So if anybody has any issues, I think, we should be good. I think we did try to accommodate everybody's schedule with that. And just thinking ahead, we'll get into the fall, right? And so we'll just be thinking about when recommendations need to be finalized for that full report for the end of the year. So I know we're way far out from the end of the year. It feels like it, but by the time we meet again, we won't be. So just targeting that fall timeframe for each subcommittee to have their recommendations finalized would be awesome. And that's all I have. unless anybody else has anything. Okay, I will move for a motion to adjourn.
So moved.
Second.
Second.
Awesome. All in favor? All right. Thank you. Have a good afternoon. I try. I try. It's easy when you have great when you have great chairs, right? So.